それでは後半を始めます。民事訴訟における専門的知見の活用について、まず各国からそれぞれ10分程度ずつ説明をしていただきます。最初は日本です。小林裁判官、お願いいたします。
はい、それでは民事訴訟における専門的知見の活用について日本の制度とその運用をご紹介します。日本では審理及び判断に専門的知見を要する専門訴訟において、鑑定制度、調停制度、専門委員制度及び裁判所調査官制度が活用されています。そこでまず鑑定と調停について説明し、次に特許訴訟でよく活用されている裁判所調査官と専門委員の説明をし、最後に専門委員の活用の実際の運用として、技術説明会方式について説明します。まず鑑定ですが、鑑定は当該分野の専門家に意見を求めて、その意見を証拠とする証拠調べ手続きです。医療訴訟を例にとりますと、例えば医師の診断や主義の適否について、その当時の医療水準に照らして判断していくことが求められます。このような判断の前提となるものとして、後に述べる専門委員とともに鑑定がよく活用されています。また、建物や土地の賃料に関して、賃貸人から現行の賃料が適正でないとしてその増額が求められ、逆に賃借人から減額が求められる、こういった訴訟があります。このような訴訟では国家資格を有する不動産鑑定士を鑑定人とし、対象とされる土地や建物の適正な賃料額について意見を求めるという鑑定が行われることが通常です。次に、調停ですが、調停は裁判官1名を含む3名の調停委員で構成される調停委員会が当事者双方の意見を聞いて合意による紛争解決を図る手続きです。訴訟と並ぶ民事紛争解決の方法ということになります。例えば建築の瑕疵が主張され争われる事件では調停がよく活用されます。調停は先も述べた通り調停委員会によって行われますので、資格を有する建築士をその事件を担当する調停委員とすることにより、建築関係の専門的知見を踏まえ、かつ柔軟な紛争の解決を図ることができます。調停委員の中に専門家を含めるという工夫は、相続紛争等の財産価格が問題となる家事事件においても広く行われていますほか、知的財産事件においても、東京地裁及び大阪地裁の知財部で2019年10月から知財調停の新たな運用が始まっています。さて、民事訴訟では判決は公開の法廷で判決書きに基づいて言い渡しがされます。判決書きでは裁判所の判断の結論を示す主文が最初に示されるほか、大きく分けると、当事者の主張とそれに対する裁判所の判断の2つのことが記載されます。このような判決書きの構成は、訴訟が大きく分けて2つのプロセスから行われていることを反映しています。スライドをご覧いただきますが、各プロセスを裁判所の立場から説明すれば、1、当事者の主張を的確に理解し、結論を導く判断構造や証拠構造を確認し、判断すべき争点を定めるプロセス。2、争点について判断するプロセスとなります。一つ目のプロセスでは裁判官は当事者から提出される主張書面を読み、口頭で説明を受けます。その際には他方の当事者の主張や双方から提出された書証の内容と付き合わせながら、その当事者の言いたいことが何か、判断の理由をどのように説明すればその言いたいことに答えたことになるか、などを考えながら主張の内容を検討します。この争点整理のプロセスが十分に行われていれば、判断のプロセスで紛争の実相に即した論理的で説得力のある判断を示すことが可能になると考えられます。争点整理を的確に行い、当事者の言いたいことを正確に理解をし、判断すべき争点を的確に定めるためには、どのような事件であれ、相応の修練を要しますが、知財訴訟、特に特許訴訟では、争点が専門的技術に関するものであることから、特有の難しさがあります。そこで以下に述べる通り、裁判所調査官制度と専門委員制度の両輪によって、 裁判官は専門的知見のサポートを受け、両制度が有機的に有用に機能していると考えています。まず裁判所調査官は裁判官の命を受けて特許権等に関する事件の審理や裁判に関し必要な技術的事項を調査する常勤の裁判所職員です。裁判所調査官は特許庁の審査官、審判官経験者及び弁理士から任命されており、知財高裁でいうと合計11名が配置され、機械、科学及び電気の各分野に分かれて事件を担当しています。知財高裁では特許権、実用新案件に関する審決取消訴訟及び侵害訴訟には原則として全件に裁判所調査官を関与させ、その他の技術的事項についての判断を要する事件にも必要に応じて裁判所調査官を関与させています。後に述べます技術説明会が実施される際には、裁判所調査官も立ち会い、当事者への質問等が行われます。次に専門員ですが、専門員は訴訟関係を明瞭にし、または訴訟手続きの円滑な進行を図るため必要がある場合に専門的知見に基づく説明をするため事件に関与する非常勤の裁判所職員です。知財高裁には学会等の各界の協力により、大学教授、研究機関所属の研究者、企業の技術者、弁理士等から任命された約200名の専門員が所属しており、その内訳はスライドのグラフにある通りです。なお、専門員は東京地裁及び大阪地裁と合わせた3庁に所属をしています。知財高裁では多角的な視点や観点から専門的知見を得るために、通常はバックグラウンドを異にする複数名の専門員を指定します。最後に、専門員の関与の実際として技術説明会についての説明となりますが、特許訴訟における専門員の関与の方法としては、通常、当事者双方の主張立証がされた後、口頭弁論記述または弁論準備手続き記述で技術説明会が実施されます。知財事件には幅の広い技術の事件があり、先端技術が争点となる事件では特許庁や弁理士出身の裁判所調査官が精通していない技術分野もあることから、実際に開発または研究している専門員の知見を活用したいという場合があります。また最先端の技術が争点となる事件でなくても、特許の有効性の判断の基準時は出願時であること、特許権の存続期間は出願から20年であることなどから、出願当時の技術水準や出願時から現在までの製品開発の状況、将来の開発の方向性などの背景事情を理解するために知見を活用したいという場合もあります。このような事件に専門員が関与することで判断のベースとなる技術についての裁判官の理解が深まり、当事者の主張の意味や技術的な位置づけを多角的に検討することができるようになり、裁判所の判断の信頼性を一層高めることができるものと考えています。技術説明会の実際の様子は本日の模擬裁判でも見ていただいたところですが、最初に当事者双方にそれぞれの主張をパワーポイント等を用いて簡潔に説明してもらうようにしています。このような方法には書面に書くと長く複雑になりがちな主張について、その要点をコンパクトにまとめるという効用もあるように思われます。また新型コロナウイルスの感染が拡大する中、専門員の裁判所への来庁が難しい事態も危惧されましたが、そのような場合には、専門員がウェブ会議の方法により技術説明会に関与する方法も行われています。技術説明会の説明は以上の通りですが、特許訴訟への専門員の関与の方法については、現在の運用が唯一のものと考えているわけではなく、柔軟な発想で工夫を凝らして、より良い審理にしていきたいと考えているところです。以上、民事訴訟における専門的知見の活用について、日本における制度とその運用をご紹介いたしました。
ありがとうございました。Next, from China, Judge Liu, could you please explain the situation regarding use of expert knowledge in your country?
In China, to better help judges understand expert knowledge more clearly in the trials, the Article 76 through 7808 of the Civil Procedure Law of China has stipulated the expert opinion system, and the Article 79 of the Civil Procedure Law of China stipulates the system of person with specialized expertise. Also, we have the relevant judicial interpretation by the Supreme People's Court. It stipulates the technical expert system. Aside from these systems, there is another more important system we call the technical investigation officer system. Next, I will make an introduction to this system. In order to regulate the participation of technical investigation officers, we also call them the technical investigators in IP litigation activities. The Supreme People's Court of China has issued some provisions on it, which constitute the basic and major regulations to get the court in China to appoint the technical investigator to participate in IP litigation activities. When the court hears patents, new plant varieties, integrated circuit layout designs, technical secrets, computer software, monopoly, and other professional IP cases, it may appoint the technical investigator to participate in litigation activities. The IP court can set up a technical investigation office, which is responsible for the daily management of the technical investigators and assigns technical investigators to participate in the IP case activities and provides technical survey opinions. The technical investigations can be regarded as employees of the court. The main function of them is to help the collegial panel understand the specialized technical matters and to further improve the reliability of the judgment in various technical fields. Compared with other systems above, the technical investigators' opinions are much more important, I have said, because they don't represent any party. They give the opinions from a fair, neutral standpoint to the court. In Beijing IP Court, we have the full-time technical investigators and the part-time investigators. The full-time technical investigators are personnel from relevant administration of department and other departments. They may serve as technical investigators in IP court for 1 or 2 years. The part-time investigators who meet the qualification may serve as they are upon recommendation by relevant associations and institutions. The part-time technical investigators are usually selected from the technical personnel in related such as the industrial associations, universities, scientific research institutions, enterprises, etc. In general, the technical investigators shall have the bachelor degree or above and should have the relevant professional technical qualifications and should have at least 5 years of working experiences in the relevant technical field. As to the status, next slide, sorry. As to the status of the technical investigators, they are judicial assistants. When the technical investigators involved in a certain case, the court will notify the parties within 3 days and inform the parties that they have the right to apply for the technical investigators' withdrawal. The withdrawal of the technical investigators shall refer to the applicable applications of the civil procedural law, the administrative procedure law, and criminal procedure law, and other related personnel for provisions. A technical investigator shall perform following duties on the technical issues involving the case, make suggestions on the focus of the controversy, on technical facts, and the scope, the order, and the methods of the investigation, participate in investigation, evidence collection, inspection, and preservation, participate in inquiries, hearings, pre-trial meetings, and trial sessions, put forward technical survey opinions, assist judges in organizing appraisers and other professionals related technical fields to provide opinions, attend the deliberation of the cases, and other relevant, complete other related work. When technical investigators participate in investigation and evidence collection, inspection, and preservation, they shall consult relevant technical materials in advance and make suggestions on the methods, procedures, and the precautions of the investigation, evidence collection, inspection, and the preservation. When the technical investigator participates in the inquiry, hearing, pre-courting meetings, and trial proceedings with the consent of the judge, he can ask the parties and other litigation participants about technical issues. The seat of the technical investigator in the courtroom is on the left side of the judge assistant, and the seat of the clerk is on the right side of the judge assistant. The technical investigators in China shall provide technical survey opinions on the technical issues before the case is deliberated. When technical investigators attend the case deliberation, his opinions shall be recorded in the deliberation record and signed by him. The technical survey opinions is independently issued and signed by the technical investigator and will not be disclosed to the public. The technical investigator has no right to vote on the result of the IP case judgment. The technical survey opinion put forward by the technical investigator may be used as a reference for the collegiate panel to determine the technical facts. The collegiate panel is responsible for the determination of the technical facts in accordance with the law. If the technical investigator participates in the litigation activity of IP cases, she also should sign his name on the judgment document. The signature of the technical investigator is under the signature of the judge assistant and above that of the clerk. If necessary, the People's Court at higher levels may dispatch or appoint technical investigators from the court at all levels within its jurisdiction. If needed, the court may apply to the higher People's Court to dispatch technical investigators to participate in the litigation activities when trying the cases involve the complicated technical issues. If a technical investigator violates laws or relevant regulation related to trial work, such as embezzles, accepts bribes, engaging in malpractices for personal gains, and deliberately issues false, misleading technical survey opinions or untrue technical survey opinions with major omissions, she shall be investigated for legal responsibility. If a crime is constituted, she shall bear criminal responsibility. That's all of my speech about this. Thank you for listening. Thank you.
Thank you, Judge Liu. Next, from Korea. Judge Kim, could you please explain the situation in your country?
Thank you for allowing me to speak on well-designed system to use expert knowledge on investigation. The content of my slide shows the type of system. I will explain one by one. Slide page 3. First is judicial and technical examiners. The Patent Court of Korea has technical examiners according to the court organization. In addition, the Patent Court and other courts require specialized examination on intellectual property rights have a judicial research officer. As of the first day, September 2021, there were 17 technical examiners at Patent Court. Judicial research officers are in court, 6 at the Patent Court, and 11 are in the Seoul Central District Court. Slide 4. This case is filed and assigned. Technical examiner and judicial research officer are technical review. Once technical examiner or judicial research officer are designated, they must submit a technical report explaining the technology at issue or opinion on the issue before the trial date. It is desirable that the judicial panel clarify and specify the issue subject to review of the technical examiner or judicial research officer before requesting their engagement. Additional technical reports may be requested at the first trial date. After submission of the technical report, judicial panel, technical examiner, or judicial research officer gather in for the trial date or the trial hearing date to have a discussion examining the technical based on the technical report. The discussion typically lasts for about an hour. This meeting is internally held and undisclosed to the party. Is distinguished from the technical review session, where the parties present the technical issue during the oral hearing. Technical examiner or judicial research officer submits their final opinion in writing on or a specific issue before the court of the judgment. Next slide. As you can see from this slide, we also use technical advisor. This is a system designed for patient hearing and prompt resolution of this dispute by listening to the based on professional knowledge and of experts outside the court, whose specialized knowledge is essential for cases related to intellectual property rights, architecture, medical care, environment, and many others. Next slide. As of the first day, September 2021, there is 657 candidates are enrolled in the patent court, having specialized in patent technologies such as machinery, electricity, electronics, telecommunication, construction, agriculture, and forest chemistry. In order to clarify the parties' relations or to proceed with litigation procedure, the court may designate the technical advice ex officio or open the request of parties and let them participate in the litigation procedure. In some litigation that requires professional knowledge, technical advice can submit their information on paper or present oral explanation or opinions in the court during the litigation. Technical advisor may directly question persons related to the litigation, such as parties, witness, relator, the approval of the deciding judge, but take in deliberation process of the judicial panel. In practice, the technical advice system is sometimes utilized ex officio or upon the request of a party. If there is no technical examiner or judicial research officer of the patent court, who is well versed in testing technical pieces, or if the technical content is particularly complex. Next slide. The technical advice system can be utilized separately from technical examiners or judicial research officers. The technical advice can be designated while a new case or can be designated during the proceeding of hearing. Designated advice based on opinions of parties, judicial research officers will have to expert who fits the case. Next slide. These slides show how expert witness system is utilized. Litigation, intellectual property litigation are proceeding pursuant to the civil procedure. Expert testimony follows the usual expert selection. According to the general principle of civil procedure. In practice, infringement litigation of patents and the party often wants to produce expert testimony to judge several persons having other skill in the time of filing. Contents of prior art, composition analysis, and the comparison of the declaration of genuine and reasonable royalty. Next slide. Let's see. The parties' active engagement in technical exploratory session. So it not solely rely on internal technical expertise. During the technical exploratory session, in which the parties, the counselors are allowed to give an in-depth explanation of the technology at issue for the date of trial, and they often use a computer or visual printer. We recommend that materials for oral arguments for technical explanations before support the date of trial, and by adding the materials to the court form, they are classified as an exception material. Through the technical exploratory session, the judicial panel has to understand the contents of the technology issue, the main argument, and the summary of evidence, and the opportunity to direct ask questions and resolve any doubt. On the date of technical appreciation, judge can understand the technology more clear compared to written explanation or simple verbal explanation about the technology, because the parties bring the product related to the case and try to explain or demonstrate the product. Next slide. I'm going to close with a little introduction of the standing members of Technical Advice Committee to Civil Action. In March 2019, standing members of Technical Advice Committee system was established to supervise the process of selecting professional technical advice for civil issues, to improve efficiency in terms of accessibility for technical advisors. As of the first day, September 2021, 14 standing members of Technical Advice are appointed to the Seoul High Court and the Daejeon, Daegu, Busan, Gwangju, and Suwon High Court. The standing members of the Technical Advice Committee are appointed by the Ministry of National Court Administration. station at the court too, and are paid. They cannot engage in any business making without permission from the National Court of Administration. Thank you for the time and interest today.
Thank you, Judge Kim. Well, at times your sound was somewhat choppy, but thanks to your prepared detailed material, we could understand the gist of your presentation. So next from India. So now, Justice Sin, could you please explain the situation in your country?
Thank you very much. In Indian legal system, we have provisions to use experts in the context of criminal and civil cases. The opinion of the expert is treated as a secondary evidence in the matter, but not as a primary evidence. The expert evidence can take place in both the court as a direct examination and as indirect examination. In the Delhi High Court, one of the interesting models of expert evidence is hot tubbing. Hot tubbing is a process in which expert from both sides is called. They are given questions. Both of them have to answer the questions, and the court can ask the questions to each of the experts in front of the other expert. There is a proper procedure prescribed for hot tubbing procedure, and I have just explained that to you. Firstly, the witnesses, the experts prepare written reports which are exchanged, and the experts can meet without the parties or the representative to discuss the report. Then they prepare a joint statement incorporating a summary of the points on which they agree and what they disagree. On the question of disagreement, questions will be asked by the courts to test the expert's opinion. So this whole concept of hot tubbing has been approved by Delhi High Court for patent cases. And this happened in the case of Micromax versus Ericsson, where Ericsson was suing Micromax for standard essential patent infringement. Under Section 45 of the Indian Evidence Act, expert evidence can be called in all civil cases. Section 115, we can rely upon expert evidence of scientific advisors in patent infringement. And Section 293 of the Criminal Procedure Code, we can use experts for criminal cases. Under Section 45 of the Indian Evidence Act, the court can use an expert for an issue of foreign law, an issue related to science or art, or even for handwriting or finger impressions, etc. But for Indian law, we cannot use an expert. The court is expected to know the Indian law. Normally, in Indian courts, in civil litigation, we can use experts for immovable property cases, for example, engineers for purpose of effecting partition between family members, revenue officials for demarcation of land. In construction-related and contractual-related disputes cases, we can use experts for establishing breach of a contractual obligation. In cyber cases, cyber experts are used for cyber violations. In the case of a person who may die or pass away, for analysis of a will, we can use testamentary experts. Handwriting experts are used in civil disputes, very usually. In the field of medicine, for example, where there is a minor involved for a guardianship, physical, mental illness, etc., medical experts are used. For comparing DNA, we use expert reports. In criminal cases also, we use for ballistic experts for analyzing the criminal issues. And experts can also be used for giving customary usages and religious practices. These are the kinds of experts we can use in general civil litigation. In IPR disputes, court can appoint a independent scientific advisor to assist the court. And for the purpose of the patent infringement, the court can tell an expert to go to the manufacturing facility to see what is the nature of the product, what is the process being used by the defendant or the plaintiff, raw materials and excipients. He can give an opinion on infringement. Scientific advisor can also give an opinion on invalidity after comparing the prior art which the defendant is citing. Who can be an expert? For example, in pharmaceutical patent cases, experts in biochemistry can be an expert. In Roche versus Cipla, a cancer doctor, oncology specialist was an expert. In Merck versus Glenmark, the inventor herself came as an expert. There can be persons who are involved in computation of damages as well, who can be used as experts. In, for example, standard essential patent cases, people who can depose about the process of prescribing standards can be experts. Someone who can map the standard to the patent claims, someone who can analyze the patents and map the defendant's product to the patent claims directly or indirectly. In order to establish FRAND rates, people in the field of economics and who can analyze license agreements can also be experts. Experts can also be used for fixing reasonable royalty on the strength of the patent portfolio and the license fee commanded in the market. In other technologies, people who are familiar with the regulatory procedures, people who can analyze prior art documents, who can explain working of a patent, manufacturing processes, who can give, relevant industry practice can also be an expert. In trademarks, for example, in disparagement or other kind of cases, advertising professionals can be used as experts. People who conduct market surveys, people who can analyze and give an opinion on damages, etc., can also be experts. In copyrights, for compulsory licensing, people who can analyze license agreements and fixation of royalties can be considered as experts. In authorship or infringement disputes, experts from the broadcasting industry, publishing industry, moral rights are also used as experts in Indian courts. Who can be an expert in India? A person with educational qualifications can be an expert. That is very understood. But even a person with experience can be an expert. In one case, there was a gentleman who did not have an expert qualification, but the court held that if he has experience in the relevant field, he can be an expert even without a qualification in that field. Now, in this, I wanted to show the single judge in this Bringo case. When Bringo was a company which was owning the Nokia portfolio, and ZTE was the defendant in this case. And the single judge held that this Mr. Regis Bates, who was the expert, he had filed the evidence. The court held that he had to have a basic degree in telecommunication. Otherwise, he can't be an expert. But the division bench said, it is accepted and recognized that a person should be an expert with a specialized knowledge by experience. Even then, he can be an expert. So this is a landmark case in India. According to me, in the coming years, we're going to have much more expert use in IPR matters. The patent rules and the intellectual property division rules, which have been notified for stakeholder comments, contemplate filing of claim construction briefs, infringement briefs, and technical primers, where the role of experts is very clearly recognized by the court. So these rules are going to come into effect very shortly. And in the proposed patent rules, a list of experts is going to be maintained by the court. And with the abolition of the intellectual property appellate board, the assessment and the understanding is that there will be more role of experts as we go forward in the future. So if any of these rules are on the website of the Delhi High Court, if there are any stakeholders who wish to give comments, the time is still there to give the comments. And this is all I want to say about expert evidence in India. Thank you.
Thank you, Justice Sin. Well, we have just seen the situation regarding use of expert knowledge in civil litigation in each country. And we observed that in Korea and India, expert witnesses are used more often than technical advisors or scientific advisors, while in Japan, we use technical advisors more. I'd like to ask Judge Kim about this matter. キム裁判官、韓国では専門家証人が多く用いられているとのことです。先ほどのプレゼンの中でどのような問題について専門家証人を用いられるかの例が挙げられていましたが、そのような点について専門家証人が多く用いられる理由というのはどこにあるのでしょうか。
実務では、技術審理官や技術調査官において先端技術の知見が十分でない場合に、技術顧問、専門委員が指名されます。ただ、先端技術が絡む事件では、当事者が専門家証人を連れてくる場合が多いのです。そうすると、技術顧問を利用する際の手続き上の負担が避けられるからです。専門機関による鑑定が採用されることもあります。実務上、特許その他の知的財産権の侵害訴訟では、出願時における当業者の水準や先行技術の内容、構成の分析及び侵害製品との比較、損害の算定、合理的な実施量を分析するために専門家証言がしばしば使われます。以上です。
ありがとうございます。今、当事者が専門家証人を連れてくる場合が多いという話がありましたが、当事者それぞれが別の専門家を呼びたい場合にはどのように専門家を決めているのでしょうか。
専門家証人について当事者が故意に出し、共同でそのものを申し立てることが望ましいのですが、当事者が故意に達することができないときは、各当事者がそれぞれ専門家証人を選び、それに従って申し立てをします。その一方のみが選べたり、原告や被告がそれぞれ2名以上の証人を選ぶこともあります。
ありがとうございます。Justice Sin, could you tell me how often expert witnesses are used in patent litigations in India?
Expert witnesses are used quite often in India in almost all patent cases. In India, we did not have researchers and technical researchers for the court. But now in the new IPD rules, we are providing for the courts to have techno-legal advisors. So going forward, I think we will have both kinds of experts, both by the parties and by the court also.
Thank you. And so, I would like to ask, how often is the hot tubbing used now?
Hot tubbing has been used in at least 2 to 3 cases recently in the last 1 year. before the COVID happened. And after that, experts have not been able to travel to India. But I think going forward, after the pandemic is over, hot tubbing is a recognized procedure, and there will be more cases where it is used.
Thank you. So, again, how about the scientific advisors?
Scientific advisors is more used in patent cases. At least in 30 to 40% of cases, scientific advisors are appointed. And in other cases, parties bring their own experts. Scientific advisors are those who are independently appointed by the court. And the parties can file objections against the report of a scientific advisor also. And therefore, scientific advisors is used sometimes by the courts, but not always.
Thank you very much. Well, it seems that the situation is so different compared with Japan. Mr.
Yes.
Shigetomi. Okay, so, Mr. Shigetomi, how do you think about the possibility of using expert witness in patent litigations in Japan?
Frankly speaking, I recognize that it is very difficult for the party to persuade the court to adopt the expert witness in patent litigation in Japan.
Oh, I agree with you. Yeah. Let's see why in patent litigations in Japan, expert witnesses are seldom used. 小林裁判官、知財訴訟で、専門家証人がほとんど用いられていない理由はどのようなところにあるのでしょうか。
はい、先ほどお話ししたところですが、日本では裁判所調査官制度と専門員制度の両輪がうまく回っているという理解ですが、その理由として、一つには知財訴訟の判断構造の特徴が挙げられると思います。知財訴訟では、技術等について適切な理解をした上で、特許法などの知財関係法令に定められた法律要件について法的な判断をするということが重要です。ですので、専門家の意見が直ちに争点についての判断を大きく左右するというものではありません。そのように専門的知見が関わってくるポイントが、判断対象それ自体というよりも判断の前提となる事情にある。こういうことであろうと思います。また、特許訴訟では双方の当事者が問題となる技術について相応の専門的知識を持っていて、そういった専門的知識を備えた当事者間での法的紛争であるというのも特徴であろうかと思います。
よろしいですか。代理人としては事件によっては専門家証人を申請したいというような事件もあるにはあるのですけれども、なかなか専門家証人申請しても認められないだろうという感覚を持っております。小林裁判官、今の韓国やインドの例もお聞きになって、どのいうふうにお考えになりますでしょうか。
専門家証人によって何を立証しようとするのかによるのだろうと思います。先にも述べました通り、特許の場合は明細書や文献、加えて学者の意見書といった書証が豊富に出されるところです。こういった内容を十分に理解することができれば、それらをもとに判断できる事件が多いという感覚を持っております。とはいえ、証人によって立証することがふさわしい事柄というのもあり得るところです。当事者から申し出があれば、その時点で採用するかどうかについて改めて考えるということになると思います。
ありがとうございます。Now, I would like to ask about the situation in China. Judge Liu, is it right to understand that in patent litigation in China, expert witnesses are not so often used, while the technical investigation officers are much valued?
Yes, Compared with other systems, the technical investigator officers' opinions are much more important for the judge, because we think they don't represent any party. They give their opinions from a fair, neutral standpoint to the court. Thank you.
Yeah, thank you. Judge Liu has pointed out the significance of impartiality. What we are talking over now can be relevant to profound notion of what is fair in order to reach a fair decision, which we shall put more weight on impartiality or the adversary system. Mr. Hattori, do you have other questions as to use of expert knowledge in civil litigation from the attorney's point of view?
Yes, thank you. Mr. Shigetomi, what Japanese attorneys especially bear in mind when dealing with cases where technical experts are involved?
Yes. Before we ask technical experts to provide their opinion, we always try to explain to technical experts what kind of technical knowledge are really important for the legal issue involved in each particular case. We believe that the technical experts' opinion are meaningful only in case that such opinion elaborates technical knowledge which are directly related to the judge's finding on the issue, whether such technical knowledge satisfies the legal requirement under the patent law. We attorneys should explain the underlying matters to technical experts precisely.
Thank you. Now, we understand that there are considerable differences in the systems and practices in each country regarding how to incorporate expert knowledge into court proceedings. When a cross-border patent infringement lawsuit is pending in multiple countries for same technology by same parties, I assume it is very important for the parties and the attorneys to be aware of the differences in the systems of each country. Mr. Shigetomi, what do you think about this?
Yes, I totally agree with Mr. Hattori's assumption. And the parties and the attorneys should understand the differences of the legal systems in various countries, including China, Korea, and India. Considering such differences, the parties and their local councils in various countries should effectively communicate with each other in order to establish appropriate litigation strategy to prove the issue of infringement and the validity of IP cases.
Have you heard anything from overseas lawyers regarding this point?
Yes, let me provide some practical tips. I heard from the Korean attorney that in Korea, the explanatory sessions are quite important in patent cases. The parties should prepare for explanatory sessions by predicting what kind of questions would be raised by judicial research officers and the technical examiners. Also, although there are not so many cases, with regard to case to which technical advisors are involved in, it is quite important for the party to study technical advisors' dissertations and personality as preparation. As to practice in China, I heard from the Chinese attorney that there is a characteristic procedure in relation to appraisal. In case that the technical issues are complex and there are special requests on method and facility of appraisal, the parties can request the court to hold the explanatory session for the appraisal institution. These practices are different from the Japanese practice.
Thank you very much. Now, I would like to know what judges of China, Korea, and India would like to expect or request the attorneys for each party to do in a patent infringement lawsuit in which judges need to understand technical matters. First, Judge Liu, could you tell me your opinion?
Okay. In China, in some complicated patent cases will welcome the parties' application for expert witnesses to appear in court. If only one party applies for expert witnesses to appear in court, the court will also give the other party the opportunity to provide elaborate explanation of the technical issues. Both parties can provide the expert witness. They can through the pictures, drawings, videos, etc., so that the court can fully understand the technical issues involved in the case. In this situation, the court will also give full play to the technical investigators by asking the expert witnesses to further ascertain the technical facts with the consent of the judge. Thank you.
Thank you very much. キム裁判官は今の点、技術的事項の理解が必要な事件において、代理人にどのようなことを希望あるいは期待されますか？教えていただけますか？
はい、お先に研究されたように、韓国では技術説明会が大事です。私は技術説明会で特許法の原則にのっとった上で、写真やビデオ、実物などのより、裁判官が技術や侵害製品を正確に理解することができるように説明していただきたいと思います。
どうもありがとうございました。難しいことを分かりやすく正確に説明することが求められているんだというふうに理解いたしました。ありがとうございます。Justice Singh, could you tell me your opinion?
Yes, I think I agree with Justice Kim that in order for judges to be able to understand technical matters, the lawyers should keep the pleadings very, very simple. The language should be simple. Technical reports can be filed with the petition or with the application, which is drafted by experts. And in India, unlike what happens in Japan, courts trust the experts of the parties, and then they decide which expert should be taken, which expert opinion should be accepted by the court than the other. So the credibility, the honesty, and the truthfulness of the expert has a major impact on the judge, because the court feels that if experts are being put by both the sides, and the plaint is drafted in a simple manner and the expert is giving a report, if the expert is cross-examined, if the witness who speaks truthfully will be believed by the court. That is what is the practice in India.
Thank you very much.
So I'd like to ask one additional question to Justice Sin. In your presentation, you mentioned that new rule stipulates about the technical primers. And so could you please tell us the purpose of making a rule of submission of technical primers?
The purpose of a technical primer is to explain to the judge the technology. The technical primer could be in the form of a PowerPoint PPT presentation. It could explain the state of the art which existed when the patent was filed. What is the step in the novelty? What is the inventive step? And how the invention has made a difference in the relevant field of technology. It need not be a long report. It can be in the form of a slide presentation also.
So is it right to understand that one of the purpose of the technical program is to divide technical matters from legal matters? Is my understanding correct?
Absolutely correct.
Thank you very much. Well, it is about time we should wrap up the panel discussion, though we prepared more questions. Now we have much better understanding of current situations regarding indirect infringement and use of expert knowledge in civil litigations in each country. Interestingly enough, even though we do have differences, it has turned out that differences among our countries are not so outstanding as they may seem from legal provisions as to the indirect infringement. On the other hand, as to use of expert knowledge in civil litigations, we have observed more differences in practice than we could see just knowing the existence of legal methods. As a moderator, I would like to thank all the panelists online deeply for your contribution to the panel discussion. それでは以上でパネルディスカッションを終了いたします。
ご登壇の皆様、ありがとうございました。